So good morning, everybody. I'd like to thank you all for joining us at the 4th Annual Employee Health and Welfare Benefits Forum. I am so pleased to see all of you. It is a gorgeous day here in Minneapolis. For those of you on a webinar, I'm hoping that it's a gorgeous day where you are too. My name is Liz Deckman. I'm a partner in the Benefits and Compensation Group here at Dorsey. And we have 3 great panels for you today. We're going to start off with a panel to my left on healthcare litigation trends. A couple reminders, folks, the seminar ends at 12:10. We're going to have a short break between the first and second, and then the second and third sessions. And at each session, there is going to be a green attendance sheet. So if you want to sign up to get credits and things like that, you have to sign each one up. We don't want you to miss out on your credits. We have approximately 300 people scheduled, registered to attend today. So thank you very much for supporting us every year. It seems to get bigger and bigger, and we hope better and better. So I'm going to turn it over to, I'm going to give it to Tim. Tim is going to start off, and he can introduce himself and the panel. Thank you.
Thanks, Liz. As Liz said, good morning, everyone. I'm going to go ahead and briefly introduce these 2 folks, but also let them say something about themselves. To my far left is Andrew Hawley. He's a partner in our ERISA litigation group, and someone I get to call frequently and talk to about different issues. And immediately to my left is Caitlin Hall. And maybe both of you could just say a word about your practices real quick.
Sure. I'm Andrew Hawley. As Tim indicated, I'm a partner in the ERISA litigation group, actually co-head of the group. We do all facets of ERISA litigation here at Dorsey, from breach of fiduciary duty claims to other sorts of equitable claims to claims for benefits, and also we've run the gamut here. So we've had the opportunity to really do every kind of claim in the world. So I'm looking forward to talking to you and boring you about it all today.
And my name is Caitlin Hull. I'm an associate actually in our Government Enforcement and Corporate Investigations group, but my practice spans a wide area, and I've been fortunate enough to work on a number of ERISA cases, often involving RICO claims as well.
Great. So I'm going to start things off here, but first a few brief announcements. For folks in the room at least, if you have questions, we'd be happy to take questions as we're going through things here. In the middle, I'll be announcing the New York CLE code for folks that they can go ahead and get that if they need New York CLE credit. I do have to make one announcement. Just before the start of the conference, I actually found people taking a selfie in here, and so I think our conference is now so notable, people are taking selfies of themselves coming to our conference, so I'm pleased to see that. It's not often that happens at an ERISA conference. I'm going to talk a little bit here on this background slide, and then Andrew's going to join in with me, but I'm actually going to start by not talking about what's on the slide and giving some bit of background here. When you think about health plan risks and sort of how things operate, and some of this is probably going to be self-evident to everyone, but I just think it's helpful to put this background in place. So one of the primary ways that health plans work to control costs is the employer goes to an insurer, a TPA, or the insurer sets up their own network. So you have people who are in network and people who are out in network. That's one of the core ways that there's an effort to try and control health plan costs. And for the entities in network, that insurer, TPA, goes ahead and negotiates with providers, and the providers say, if we do this treatment, we'll charge this, and if we do this, we'll charge this. And that's the way that things are done to control things. If you go out of network, on the other hand, there's going to be a higher cost, and the insurance is going to cover less. So one of the things here, we've got most of the people attending this conference are employers. There's also though people who are insurers and TPAs, people who are providers. I guess the thing that all of us would agree on is the best thing in the world in a health plan would be clarity. I think a lot of things come up because things aren't clear. Another wonderful thing, and unfortunately this is something that all of us wish we could do more about but probably can't, and it's just a fact of life, is we'd like employees to actually pay more attention to what the health plan says. Because that would probably solve a lot of the issues that we're going to be talking about here today. The things we're going to be talking about is, if you go through here in a second, we have a quick overview, but you'll see things we're going to be talking about: subrogation language and assignment of rights language and other language. And it's one of the things where we try to work, on both ends, both in the litigation aspect and also in the benefits practice here, which I'm in, where we work with employers to try and help them in the language in their books, or we might work with an insurer or a TPA on the language in the materials it provides, so that hopefully there's clarity. Because the last thing people want to do, even though these are the nicest people in the world, litigation is not where anybody likes to end up going to pay a lot more money. And so what I guess I think is the goal, I'd say, for everyone in many ways is clarity and trying to get the terms right, and then hopefully finding the best way possible to communicate those terms so that the people who are participants in the plan, the dependents, understand those terms as best as possible, so there's fewer disputes and other things. I will say, even if that wonderful world could come into being, there's still pressures all of us experience, and there's market pressures and others, and I'll just give one example here, and this is just an example of how things play out. You get situations where somebody feels too much has been paid, or some service costs too much. A recent example is that a few years ago, North Dakota enacted a law that placed a cap on the fees paid for air ambulances. Enough of the individuals in North Dakota contacted enough representatives and senators. The legislature in North Dakota said, this is crazy. People are paying 40, 50, 80, more, thousands of dollars for an air ambulance. They shouldn't have to pay that much out of their own resources. We're going to cap air ambulances at whatever the insurance company allows. Anything else you can't bill to the employee. Well, what does that do? I think I am not an economist. I try to learn a little bit about being an economist maybe, but you can understand if you place those restrictions on services and things, you're going to have other net results that you're not going to be happy with. You might have fewer air ambulance providers. You might have situations where there's difficult choices. Or let's say that you have the situation where, and we'll talk about this somewhere, there's complete disclosure. This air ambulance trip is going to cost you $80,000. It's out of network. You're going to be paying $60,000. Does that mean that we're then driving people to drive an ambulance for 7 hours to get from one hospital to the next? Maybe. I don't know. At least then, that might be an unhappy situation, a sad story, but at least then there's clarity on what's being expected here. And it speaks to sort of our society in general. We want to make sure people have access to health care, but also then the cost of health care is the really hard thing to control. So that's a big windup to a topic that we're getting into here. Andrew, do you want to maybe talk a little bit about the background on health plan litigation here?
Sure. And I guess we'll talk a little here about what we plan to do today. I think that what Tim said is very good, and one of the, if there's one kind of message to everything, it's clarity. Every time you get into litigation, you always are kind of it's a bit of a historical project in the sense that you're looking back on what's happened and you're looking through documents and years and years of preparation and things like this, and you're always it's inevitable that there's always things that are there's always a little issue there, a little issue here that you're dealing with. And I guess if there's another point today is that that by preparing a little bit, you can by getting your documents in order and by having certain terms, plan terms and things like this, you can be in a much better position if the litigation does happen. And it doesn't take a lot, but there's just simple things that you can do to prepare yourself to make sure that your plan is prepared if you actually get involved with it. We want to do two things today. First of all, we want to kind of summarize some of the major areas of litigation that seem to be out there right now. And just very briefly, so you understand it, not to go into a whole discussion of it, but you understand what the claims look like. And then we're going to kind of go through some of the plan terms that might be effective for you, that you might have the opportunity, or plan terms or other document terms or other things that you can do to prepare for the inevitable litigation which will come up. The first thing the first kind of claim that we really don't have a slide for, but is apparent, is just the simple claim for benefits. This is just a participant seeking benefits under the terms of their plan. Oddly enough, Tim refers to the air ambulance claims, and for whatever reason, that seems to be a very, very common claim these days. These air ambulance providers, are regularly charging $200,000, $300,000, $400,000 to shuffle people around to receive emergency services. They're almost always out of network, or at least the claims are always on behalf of people out of network, which is an interesting phenomenon to see those out there. I just mentioned that just because Tim did as well. And we'll go through the out-of-network provider litigation, the surprise billing litigation, and all the other ones listed there. So we'll just start with the first one, I guess. Out-of-network litigation is...
Yeah. So out-of-network providers are suing plans and third-party administrators at a pretty significant rate. We're seeing these a lot. And often the claims are falling under ERISA, which requires an assignment of claims. But these claims are also often including state law claims. So we're seeing promissory estoppel, breach of oral contract, and other claims like that arising from these out-of-network litigation cases as well. And there are a lot of different examples of this. We took a look at some recent dockets, and there was a case filed just on May 3rd in California where an out-of-network health care provider brought state law claims for, I think it was breach of oral contract, as well as promissory estoppel for what would otherwise fall under ERISA.
And these are endemic claims, and they're just everywhere. And the main claim, or at least one of the principal claim, is usually a claim under ERISA, and then what happens is you get this huge fight as to whether or not the medical provider has a proper assignment of benefits from the patients, and they can have literally 200, 300, 400 claims from individual participants. It kind of becomes this case where it's almost a class action, where you don't have to actually certify a class action in some ways. And then you get in all these really technical ERISA fights about anti-assignment clauses and the scope of the release, and can they get equitable relief, and just really mind-numbing stuff. So that's the ERISA side of things. And on the non-ERISA side of things, you have a series of state law claims, which inevitably are, hey, you know what, when patient X came here, I called you up, you say, the insurance company said, I called you, being the insurance company or the plan, the claims administrator, the third-party administrator. You said this person had coverage. You promised me that you were going to pay whatever I wanted to charge, which is usually not true, obviously. You promised that you'd pay whatever you wanted to charge, and you promised you'd pay it no matter what, and you didn't care if it was, like $10,000 television to programs or whatever it is. You promised to pay. And the insurance company says, no, we just kind of verified that they're a participant in the plan, and we never told you anything. And then, so that comes up with, there's a whole series of state law claims that come up there, and then the inevitable question is, are they preempted by ERISA? So this has just spawned just an absolute ton of litigation. And what's happening in some instances, normally the third-party administrator is the defendant to it, but in a lot of instances that we've dealt with, in particular one case, what the plaintiffs will do is they will name all the group health plans and their plan administrators. It's just a way to kind of, you could literally have 400, 300, 400 defendants there. And it's just really a way to it's not necessary. They don't need to do it. At least, in most circuits they don't need to do it, but it's just a way to kind of increase pressure, make it just difficult to administer, and frankly to try to force the plans themselves to get the TPA to settle the case, because they're just annoyed by it, and maybe they hopefully think that the plaintiffs think that they can get some sympathy from them. So those kinds of claims are endemic. Don't be surprised to find that if you're a health plan sponsor, that you yourselves will be targeted once. And I guess I'll just say one last thing, sort of as an ancillary point to this. There are sort of third parties that are sending letters to basically everyone in the world, threatening, the DOL is going to come and take over your company, that you've engaged in prohibited transactions, that if you don't, give us these documents, it's going to be $15,000 a day and for forever. I'm being facetious, but it's very common to see these kinds of letters on behalf of third-party providers, threatening threatening everything in the world if you don't provide documents, and if you don't go to Aetna or to Blue Cross Blue Shield or whoever your third-party administrator is, and force them to do something because they've denied medically necessary care or not paid them enough. Those letters are very, very common. Sometimes they're a lead up to actual litigation. Oftentimes they're just threats. The big thing I would say about those is don't believe everything they say. They just, it's funny, and some of them are hilarious because they're literally 30 pages of just like single space text that just makes no sense. It's obviously just like, just computer generated. And they, just because they say something, I guess the best thing I would say, just because they say something's true doesn't mean it's so. And just because they say you're entitled to give, that you owe them documents or this, it doesn't make it so. I guess that's the best thing I would say, so.
I might just add two other additional thoughts here. So, again, this goes back to my initial little soliloquy about what are we after clarity. But, out-of-network providers, if you're somewhere and you need some life-saving treatment or something, and the out-of-network provider provides it, I think everybody would say, well, that person probably deserves whatever fee it was, et cetera. But one of the difficulties here, and I think this is a challenge again of health plans, insurers, TPAs, everybody's trying to figure things out in a way. The providers are bringing these claims because they obviously think they should have received more for their services if they're out of network. And one of the things we're seeing on the benefit side is that we are seeing more and more employers working to narrow their networks more and more. We're seeing more and more high deductible health plans, which means that there's more and more costs that are put onto the employees. And so that's one of the reasons we're seeing this trend, right? There's other things that are also driving this trend in this type of litigation. So just a quick thought on that. Surprise billing. This has been making the newspapers or store rounds a bit, and it's something that's actually before Congress even right now. And I actually came across a little survey, some information. So this was by the Healthcare Institute or something, looked at claims from 2016 in 37 states and the District of Columbia. And what they found was that the 8 highest states in terms of surprise out-of-network medical bills were Florida, with 26% of the medical bills being surprise out-of-network claims, closely followed by Kansas, New Jersey, California, and Texas, all with 20% or more, Maryland, Nevada, and Alabama. Well, you can guess by naming Florida, California, and Texas, I've just named 3 of the most populous states in the country, and they're all in basically 20% of the medical bills are surprise bills where some out-of-network amount is being paid. You can see why a lot of people are experiencing it. The 8 states with the lowest share, Minnesota comes in number 1 at 2%, thank goodness. It probably means a lot less work for at least the people in the room here, if not those participating via webinar. Other states with low percentage of surprise billing include Iowa, Maine, Wisconsin, Oregon, Utah, Kansas, and Colorado. So it really varies where you are in the country, and it probably varies then based on practices of the provider. So one thing I guess I would think is that might mean that hospitals in Florida tend to admit a lot more of out-of-network providers maybe do anesthesiology or certain other services. And then the person who goes in there says, oh, I've gone to hospital A and it's in network. But then some of the people providing services at Hospital A aren't in network, they're out of network, or there's other situations I'm sure that can arise. And so these surprise bills come up. We'll keep talking air ambulance a little bit, but obviously I'm guessing that in most cases that air ambulance situation that I talked about earlier, again, the people didn't realize in advance that they might be responsible for 10, 15, 20,000 or more dollars in air ambulance bills by selecting the air ambulance route or having to take an air ambulance instead of getting other transportation. As the slide notes, this comes up when the patient is left with the balance billing. So the situation is really you've got an out-of-network provider. They go to the insurance company. The insurance company says, well, our customary rate is X. Let's say it's $5,000, and we'll give you 60% of that. And so here's $3,000, and the bill is $30,000. And the person who got the treatment then is left on the hook for the $27,000 balance billing. And the note goes out to them. Dear Tim Goodman, I hope you enjoyed your air ambulance ride. It was very scenic, we're sure, and now it's only $27,000 in fees. And so, of course, politicians are going to want to try and address this. And so there's President Trump directed cabinet officials to work to address it. In Congress, there's actually some bipartisan legislation that's making its way through that's trying to think about, well, maybe if you have a hospital or a healthcare provider or healthcare entity, you have to guarantee everybody at that entity is in network. If the person is, if you're in network, anybody performing services at your entity has to be in network. And there's other things that might be done. But much like the earlier air ambulance situation, my one concern, this is sort of, healthcare is like a super large balloon. It's like a balloon the size of the moon, and you squeeze somewhere and it always has some other results. And so we'll see what actually happens with this bill, but to the extent that you require people to be in network at a hospital, let's say that the practice has always been that you've gotten your anesthesiologist or whoever from outside the hospital, are you able to hire people, or will they just say nope, and then you don't have an anesthesiologist to perform services at your hospital? It's a very complex situation, and so we'll have to see what that comes up with. A number of states have already passed legislation. So, for example, California, being the top on the list, is being a fairly liberal state, is very active in things, and they've already passed legislation. But as we all know, legislation in some ways only goes so far, again, because of ERISA preemption. So the vast majority of people who are, not Medicare eligible have their insurance through an employer. Those employer self-insured plans aren't subject to state insurance laws, and so that's why there's an issue now also at the federal level in trying to think through this. This is another way, it's called surprise billing. It's really sort of a subset of out-of-network billing issues, really. But it's something where we wanted to take a moment just to talk a little bit about that and the fact that you'll be seeing more on that. And, you know, this is an unfortunate situation where, especially the employers, I'm sure you get, occasionally we'll get a discussion where somebody will contact you and say, I have ended up with this additional bill. Is there anything the employer can do to help me or take care of that bill? Again, trying to find ways to help employees better understand the plan, but that's a tough order too. So service provider litigation, Andrew, do you want to see if
one of the very common types of litigation that we're seeing today would be service provider litigation, what we've called service provider litigation. And by the way, just if people do have questions, feel free to answer. We'll leave some time at the end, but of course, if you have questions now, feel free to ask them. You know, what we've termed service provider litigation, which are essentially claims. They usually tend to be class actions against third-party administrators for health plans and those who also provide services to health plans. And in essence, what these claims that we've characterized them involve claims under ERISA, usually under ERISA, but also sometimes under RICO and also sometimes under state law. That the service provider, so one of their practices violates ERISA or violates a contract. We've kind of mentioned the Cigna case there just as an example. And the Cigna case there, you know, Cigna had, we worked with an entity called ASH. The allegation is that ASH essentially had, you know, charged additional fees to participants, kind of hid fees to participants that weren't justified and weren't called for by the contract. We're also aware, for example, of a claim, not mentioned on this, but claims, I know that there's been 10 to 15 years of litigation against a Blue Cross entity in Michigan that in a case that we're dealing with, where literally dozens of cases have alleged that Blue Cross put a secret fee essentially on all of its bills for a very, very small amount, but obviously over time it adds up, and this was not justified, and the court ultimately would hold was a breach of fiduciary duty under ERISA, and resulted in, again, another 10 to 15 years and literally dozens of cases by plans and participants saying that this was a breach of fiduciary duty and otherwise not justified by contract. And we're seeing a lot of those kinds of cases, sometimes in individual cases brought by group health plans who are upset by some of the practices they've seen, but more often by participants in class action type situations where they've alleged that this was a wrongful behavior. And I think we're going to see more and more of those as time goes by. Caitlin's going to talk about the PBM class actions a little bit.
Yeah, as kind of a subset of service provider litigation, we're seeing class actions against pharmacy benefit managers and their involvement in plans, essentially. And a good example of this is a Cigna case where Cigna is alleged to have taken improper clawbacks based on the difference in the contracted price for prescription drug benefits and the price ultimately paid by plan participants. So this is kind of a subset of the service provider litigation that we're seeing pop up around the country.
Right. And it's just as in the Cigna case we're mentioning, and there's others as well, but in the Cigna case we're mentioning, you know, the allegations are both under ERISA and also under RICO. And the claim essentially this was not just that these clawbacks and the amount that you received was not justified by the plan. Of course, those are just allegations. It doesn't mean they're true, but it's a common theme to a lot of these kinds of cases where people will charge that the service provider engaged in some practice that's improper into the plan or ERISA. So another set of kinds of cases are just ERISA fiduciary litigation. Sometimes these are class actions, but you know, this Fry case is a perfect example of the kinds of things you're seeing right now. Part of this has to do with some technical changes to ERISA that have happened because of Supreme Court precedent, and I'll spend 15 minutes now describing the scope of 502A3 relief. No. But basically what it is, these cases usually involve some kind of miscommunication by the employer to a participant, and as a result of that miscommunication, the participant's benefits are as adversely affected. You know, this Fry case is a good example where they got bad advice about life insurance, and as a result of that, the participant wasn't able to qualify for life insurance in a proper way. Premiums weren't paid, deadlines were missed, forms weren't filed. That's kind of a general theme of these things. And as a result, the employer, who is almost always a fiduciary, allegedly made a mistake in communicating benefits, or in some instances didn't just make a mistake in communicating, but failed to affirmatively give information to the participant. And normally that failure to affirmatively give information wouldn't be a problem, or at least wouldn't be actionable. But under ERISA, because you're a fiduciary, in some instances you have a duty to go a little further. If you know, for example, at least arguably, if you know, for example, that the participant's confused about something and you can give them information that will help them, or if you know they're really trying to achieve this thing and there's some piece of information that you could give them to help them achieve this outcome and you don't provide it, well, at least the plaintiffs might argue that that's a breach of fiduciary duty. And one of the developments in ERISA remedial law is that once upon a time that you were kind of out of luck, but now courts will say that, well, even if you as an employer failed to tell somebody how to properly sign up for life insurance benefits, and that person, as a result, the life insurance company is not going to pay their benefit, you, the employer, may now be on the hook for it because you breached your fiduciary duty by failing to provide them with proper information. Again, a case that is a result of some Supreme Court decisions we're starting to see more and more of.
Mm-hmm.
So ERISA interference claims fall under Section 510 of ERISA, which essentially says that employment action cannot be taken against somebody with the specific intention of interfering with that person seeking ERISA benefits. And Stein is a great example of a case that the court has held breached is at least the basic level of pleading a potentially successful interference claim. And in Stein, the Sixth Circuit looked at a lot of evidence of what the employer actually said to the employee prior to the adverse employment action being taken. And in that case, the former employee's son had a significant amount of medical expenses over a period of months and months, which had given the employer plenty of time to comment on the expense of those costs. So evidence came in that the employee's boss multiple times mentioned the employee's son, hoping that he'd be out of the hospital soon, that the costs were pretty astronomical. Somebody in HR showed the son's medical bills to somebody else in HR, mentioning that they were far exceeding what was expected. And then the employee himself went out for some sort of medical procedure and came back and was terminated. And the Sixth Circuit said that under these facts, there's pretty clearly a basic interference claim stated, just based on the timing and the evidence of actions taken by an employer.
And I might just jump in for a second here. Obviously, employers have to face the rising costs under their health plans, but it was interesting to me, especially when the Affordable Care Act was getting implemented and the employer shared responsibility was coming online. And a number of employers with under, say, 200 employees who had sort of done maybe not perfectly uniform treatment of their employees or something, I got these calls like, well, I've got this employee and his son has got about $200,000, $300,000 in treatments. Isn't it possible for me to simply pay them so they can go on the exchange or do these other things? And I hear the employer's concerns and things, but what this Section 510 is not very well known out there, I guess, and it's a nice thing that it got put into the slides here in part, because you need to be very mindful, even beyond things like HIPAA or other things where you might be using medical information in an appropriate manner for employment decisions. These 510 claims can occur. And I'll give one other example, and healthcare is very political these days. Lots of things are very political. Healthcare is very political. But there was a case, I don't know how many of you are familiar with this, Buster and Dave's, where, again, the Affordable Care Act was enacted, and the owners of Buster and Dave's, a restaurant chain, said, we are never going to go ahead and cover our employees under health insurance. It costs too much. We're going to drop everybody's hours to 30 hours. And they had statements in their SEC disclosures, and they ended up settling for, I think it was $6 or $10 million on ERISA Section 510 claim. And it was just because they'd made all these statements. I think it's very important when you have these complicated situations. It's never inappropriate to go out and talk to your attorney or somebody about that, but internal discussions, you want to be mindful of who's doing what, and do those people have then some control over the employment relationship in terms of the entity.
I would also say that Stein was a pretty far out there example of some of the employer conduct that we were seeing. But some of the other things that the court mentioned when they were looking through the evidence were things like notices to employees by the employer with renewal paperwork for insurance saying that they were concerned about the rising cost of healthcare, and some of those things that you might not otherwise think twice about sending out, that when paired with some bad conduct by an employee or two employees can give rise to interference claims.
So Andrew, I think you were going to talk a little bit about mental health parity.
Yeah, so the Mental Health Parity Act was enacted, shortly before the Affordable Care Act, and a lot of its provisions are not really all that relevant anymore, simply because they've been superseded by the Affordable Care Act. But there's still some provisions that are very, very important and not very well understood. Among them are the what they're called the non-quantitative treatment limitations. And at a high level, what that means is that both your health plan on its terms, but also in practice, they have to cover mental health. They have to cover mental health treatments and mental health conditions, as it would similarly situated treatments on the medical side. Now, the phrase what I just used for similarly situated medical treatments is not exactly what the parity limit, the regulations say, and they also carry a lot of weight. I mean, what does it mean to say similarly situated? Well, we're starting to see a lot of litigation about that kind of thing. We're starting to see a lot of litigation where the plaintiffs are saying, hey, you know what? You had these restrictions on mental health benefits, and sometimes they are a complete refusal to cover certain things, but also sometimes they're just a situation where the systems that you're using, the practices that are using to verify the need for the mental health treatment are what plaintiffs would characterize as more stringent than what a similarly situated medical treatment would be. And the plaintiffs will say that that's a violation of the Mental Health Parity Act, and therefore, because that's incorporated in ERISA, that's a violation of ERISA. And they're very, very hard cases because they're very hard to determine. First of all, the regulations are hard to understand, and they're hard to understand exactly what, and second of all, it's very hard to figure out what does it mean, how is a mental health treatment similarly situated to a medical treatment. And it's hard to understand, but the plaintiffs are raising these claims more and more, and you can see the plaintiffs' bar becomes more and more sophisticated about things as more and more cases. They start to kind of absorb things, and they start to understand how to advocate those kinds of claims. Well, we're starting to see more of those. The Munley case cited in our materials here is interesting because it's the group health plan excluded residential mental health treatment services. And this was improper because the court held or at least arguably, because on the mental health, on the medical side, you provided those kinds of residential those residential services in the form of skilled nursing care. So, for example, you wouldn't. So, under this plan term, which was problematic, you wouldn't be able to get any residential health treatment services, for example, for anorexia. But if you had a heart attack and you needed, 24-hour care in the form of skilled nursing services, you got that. Well, that was problematic because at least arguably you had something that was somewhat similar in the sense you had 24-hour care that wasn't it wasn't hospitalization, but it was just sort of a step down, and you offered it for mental health services, for medical services, but not for mental health services, and the plaintiffs alleged that was problematic. The second case there was a situation where they refused to dismiss claims. The court refused to dismiss claims for an individual who had anorexia because they would not provide nutritional counseling for them, but they would provide nutritional counseling for non-mental health conditions such as diabetes. And again, it's a very difficult thing to try to compare apples to apples or apples to oranges or whatever metaphor you want to use. How do you determine? And of course, everybody's mental health services are fundamentally different in the sense that they're much harder to determine whether or not they're medically necessary. They're much harder to control costs in a lot of ways because you don't have the same kind of objective evidence necessarily, at least arguably, that you would have on the medical side. And so therefore it's much more challenging. I think from a defense side, it's much more challenging it's much easier for a plaintiff to kind of say, oh, these are comparable, and it's in some ways challenging on the defense side to be able to find the evidence to show that they're comparable because there's just different conditions on the mental health side. But the regulations say what they say, and you just have to deal with them.
Yeah. Do you want to talk about
Yeah, the other two, I mean, we had, there's other, of course, other kinds of litigation that we haven't talked about. We haven't really talked about privacy litigation, which is not really ERISA specific, but as I'm sure you all have encountered at least at some level, privacy litigation in healthcare is a very big deal. We also haven't talked about a lot of how group health plans are, filing their own claims. There's a lot of money that group health plans are losing out on in one form or another because of overpayments, because of fraudulent providers, because of antitrust violations, because of RICO violations. There's a lot of money out there, and you're starting to see health plans get more and more aggressive about trying to recover it. We haven't talked about that in depth, but that's something that's out there, and it's something you should be aware of. That you probably have potential claims against people to recover money. Mm-hmm. But we wanted to shift now to sort of the talking about just general principles that we think, general principles to try to prepare for litigation and some specific things that you can do for your group health plans. The general principles we'd say here is just, it's very, whenever litigation comes, you're getting a stack of documents and everybody's trying to, and it's a reflection of, years and years and years of work and sort of day-to-day business. And, one of the things that inevitably happens is, you set your health plan up and there's changes over time and the documents don't necessarily reflect all those changes. To give, the most egregious kind of example you can imagine, I remember we've seen situations where you have a health plan that contracted with Aetna to provide a third party, to have a third party services. They later changed to Blue Cross Blue Shield, and none of their documents were ever really properly updated. Everything still said, Aetna. And it was challenging because, you're trying to go to a court and get something dismissed on an early motion or something like this. And it's challenging because all the documents say the wrong things. And how is the court supposed to feel comfortable with the idea that everything's in order here if the documents don't even say the right things? And so I think that the number one principle is just keeping everything up to date, making sure that all the I's are dotted and T's are crossed and things like this, to make sure that if there ever comes a time when you have to present who your plan administrator is, do they have discretionary authority over claims? Do they do they have the right to do this or that? That the documents are up to date, so we can present them to a court in a very unified fashion and make it very clear what's going on. And the other thing is too, I guess, would say just keep up to date on litigation. It's stunning how often they'll have a plan term, an anti-assignment clause, for example, or discretionary term, and you'll think it's just perfect. But all of a sudden, you've got these changes to litigation that where courts will all of a sudden take a left turn, and all of a sudden your document is just totally out of it. It just doesn't effectively achieve what you want it to achieve anymore. Well, that's problematic, and the only thing to be done about it is just to try to make sure that you're verifying things and keeping up to date on your plan documents, because these are always fluid things, and they're never really set in stone, at least if you want to be effectively prepared for litigation.
Yeah. So, as Andrew said, we're switching to practical steps for you. I mean, we can talk to you all day about litigation, and as long as you're not being litigated against, it's good to know those things, but that's not as helpful as what can you do to more protect yourselves and try to think about, again, clarity. What are you going to do with your employees, the participants, and documents? And so here we are, and we're on slide 12, and we're talking about what is your plan document, controlling and defining your plan document. And really the first question in many ways is, what is your plan document? The Department of Labor basically has said, you get to define on the welfare side, what is your plan document? Do you have just a single standalone medical plan? Is that an insured plan? Is it a self-insured plan? Or is it part of this comprehensive WRAP plan document? And the medical program is just one part of it. A number of employers, for many reasons, like that WRAP plan approach, because it might then simplify Form 5500 filings. It might make some other things a little easier. You can have one document where you attach a whole host of things like QEMSCO procedures or maybe a HIPAA amendment of things. But you need to know, as a starting matter, what is your plan document? Is it just this health plan, or is that part of a comprehensive welfare plan? And so it's important just to say, okay, that's first. The second thing is, what document actually lays out, say, your plan's terms, a medical plan? And, depending upon factors, you could have a number of things here. We have some of these on the slide going down there. Is it, do you have some sort of combined summary plan description plan document where one booklet serves both functions? And that's very common on the medical side to do that. Or do you have multiple pieces? So sometimes I've seen it where a client has an insured plan, and that insured plan basically just says, this is not enough. In essence, it says this is the certificate of coverage, here's the benefits covered under the medical plan, here's how you file a claim, here's some other information, but it's still not an ERISA SPD because it doesn't have the ERISA rights section, it doesn't have the plan contact information, and they're expecting the employer to put together a little booklet to supplement things. And it's so crucial that you take a look at that. And we're going to get into some language. Both Caitlin and Andrew are going to talk about language in a minute here about some of the things we're talking about already, like the assignment of benefits, subrogation things. But really, this whole starting point is saying to yourself, okay, what is our plan document? When is the last time we updated our plan document? And how have we communicated our plan document? One thing I'm going to turn over to Andrew in a second here, proper communications, I'm going to jump into kind of in a minute though. A lot of employers will go ahead and update their plan document for their health plan every year. And usually it's happening, oftentimes the SPD for the current year is not getting out until about now or May or April, just depends on things, but you want to get that out. But now is the time that you're already being contacted by your insurer, TPA, to say, what about next year? Are you going to be making changes to your health plan? Are you going to cover this new treatment? Are you going to do this or something else? Well, this is a good time to start thinking about, as you're going through different benefits and what your premiums might be and looking at all those other things, to maybe say to yourself, we're going to do one extra step this year, and we're going to look at 4 slices of language, which Andrew and Caitlin are going to get into again, that assignment of benefits and other things. The other thing to think about is, how are you distributing that plan document to people? I have not really seen many cases about failure to distribute or somebody relying on maybe an outdated booklet or something else, or saying you never really distributed updated booklets to me. But as probably everybody in this room knows, and everybody participating by the web knows, the DOL has some very straightforward rules in a way about, in order to distribute a document electronically, you have to make sure that person has ready access to your electronic communication system to do it. So if you have people, let's say on COBRA, or if you have people in other situations who don't have that electronic access, you will not have effective distribution unless you do a paper copy. The good news is the Department of Labor is actually looking at those regulations, and there's some small chance, I will hold out hope, that they liberalize that a little bit. But that's another aspect of thinking about plan documents here. Andrew, do you want to talk a little bit about delegation and some other things here?
Yeah, so, I think that when you're talking about your plan, first of all, this is just kind of an extension of what I was saying earlier about making sure everything's in order. But make sure that your plan documents are up to date, but also your ancillary agreements with your service providers. And and I think when you think about it, again, if we get a case and we're looking at your plan documents, we'd like to be able to present them to a court and say, look, if you look at these plan documents, you're going to see these things are self-defining. They're going to tell you exactly what in the best of all worlds, and everything's ever always the best of all worlds. I know that, obviously, but these things are self-defining. They tell you what the plan document is. They tell you, the SPD serves as this. The certificate of coverage means this, and something that presents it to the court in a way that it understands, where it can say, yes, I know what the plan document is, and I know that these other communications to employees, which may have some ambiguous language, are not formal plan documents. And you want to be able to present it such that that can be shown to a court as the case, and the court doesn't feel like it has to kind of dig behind the documents to understand what's going on. Properly communicating terms is really important, not just in the SPD. And like, for example, we're going to be talking about statute of limitations and venue provisions. And it's very, very important to make sure that those things are in your SPD so a court can feel comfortable that a participant understood it. And also, and particularly with statute of limitations, for example, that should be something that should be communicated to a participant. If, for example, there's a denial of benefits, a wise thing to do would be to say, hey, not only we're denying your benefits, but we want you to know that you only have 6 months or you only have 1 year to appeal this, to file a claim about this, because otherwise, if it's lost a little bit, because the court will say, look, you sandbagged them, or arguably could say you sandbagged them, because the only way they were supposed to know that you had 6 months or a year to file a claim was if they dig into the interstices of the SPD, and a lot of people don't do that. And you'll be seen, oftentimes employers are seen as a fiduciary when they're engaging in these kinds of activities. So it's important to understand that you have to take it from that guidepost as if you're a bit of a fiduciary, as if you are a fiduciary, and that you're communicating with the employee in that fashion. Mm-hmm.
Caitlin, do you want to talk about differential review?
Yes. So one of the first things that everyone's going to want to make sure that their plan has is this Firestone deferential review standard. And basically what Firestone says is that a plan can adopt language that provides fiduciaries discretionary authority to both interpret plan terms and determine eligibility under the plan. And this is a really key thing to have on your side during litigation. If you're able to avoid the de novo review standard that a court would otherwise apply to a claim for benefits or another claim, in favor of the much more favorable arbitrary and capricious standard that applies where we have the Firestone deferential review. And it's also really important that when this language is put in there, that it does apply to more than just determining eligibility or claims for benefits. It really should apply to all claims under the plan, including interpretation of plan terms. In addition, you'll want to make sure that the deferential authority and this discretionary authority is both clearly written, but also updated. So again, this goes back to making sure that the plan is as clear as possible and stays updated throughout time. But if, for instance, the plan established deferential authority or discretionary authority for like the VP of HR, and then that position gets eliminated or restructured at some point in time so it no longer exists, it's less clear for the court whether the deferential standard applies and whether that there is really a discretionary review standard if the plan language hasn't been updated to reflect what is actually happening at a company.
And this is kind of an example of a situation I was mentioning before. Kind of keep updated on the law. This gives kind of a good a good real world example, I guess. Once upon a time, everybody thought that this different deferential standard of review, which essentially says you can make decisions and a court will review them to make sure only to determine whether or not they're reasonable, not necessarily to determine what they're right. Whether or not they're the perfect decision, only to determine whether or not they're reasonable. And if you have that language, it can be very, very helpful in litigation. And once upon a time, courts would, this was kind of commonly applied in claims for benefits, where if you had this language in there, if you're saying, hey, the person X has the discretionary authority to make determinations about the plan, about claims for benefits, you would go into litigation, and as long as you were reasonable, it was effective. Well, courts started to expand that a little bit and say, well, this shouldn't just be claims for benefits. This should be things like investment decisions. It should be things like, decisions about service providers and things like this. And we really want to say that, as long as you have this discretionary authority, we're going to judge it under whether or not you're being reasonable, not whether or not you're being perfect. Mm-hmm. But what happened is a lot of people didn't really, the plan documents didn't really get updated. So you saw a situation where the plan document would just say you have discretionary authority to decide claims for benefits. And you'd get into a litigation situation, and then the language just wasn't there, it wasn't broad enough. And had you had the opportunity to expand it, you would have the litigation may have gone more favorably, or been easier to at least deal with and address.
Yeah. All right. Exhaustion plan remedies, Andrew?
Yeah, so, one of the other, as I'm sure many of you know, ERISA has a claim for benefit process, and that process essentially says that before you can go to court, you have to go exhaust your claims before the plan fiduciaries. And before plan fiduciaries. And in most instances in the group health plan, that's at least starts off with a third-party administrator who decides claims. Oftentimes they will finalize the decision on the claims, but in some instances the employer will have the final decision on a claim for benefits. And again, in most instances, courts generally require that that claim for benefit process be exhausted before litigation can ensue. Well, one of the things that we're seeing right now, and kind of talking about, going back to the point of courts updating things, is that courts have increasingly said that exhaustion is only required if the plan document says you must exhaust. Once upon a time, that wasn't really so much the case. It was just considered statutory and mandatory. But now we're starting to see courts say that, hey, the plan document has to explicitly say that this claim must be exhausted before you can go into court. So updating your plan language to make sure that's clear can be very, very helpful. And you might even consider it to be broader than just a claim for benefits. In some circuits, you actually have to exhaust breach of fiduciary duty claims too. And if that's something you want to have done, there's no reason not to have your language require it. It might not be effective in some circuits, but in some circuits it will. How you exhaust a large, multi-million-dollar breach of fiduciary duty claim about this or that, it's a question as to whether or not you want to do that. But if you do, it can provide you some significant protection. And as we just talked about, if you get into litigation, the decision on a claim for benefits may be reviewed for discretion. It may be reviewed under abuse of discretion standard, meaning if what you did was reasonable, if your determination was reasonable, it will be effective.
So we have just over 10 minutes here, so we'll have to do about 2 minutes a slide or so, but anti-assignment clauses, Caitlin.
Yeah, generally speaking, anti-assignment clauses are what they sound like. They're provisions that say that a participant's benefits under the plan cannot be assigned to someone else. And courts have held repeatedly and regularly that anti-assignment clauses are both valid and enforceable.
Yep, and so the normal anti-assignment, the traditional anti-assignment clause will just say you can't assign any of your benefits under the plan. Well, there's a couple of tweaks to it. First of all, it should be broader than just saying you can't assign your right to benefits to a medical provider, because there's other ancillary things under ERISA that you could assign. For example, if you just because you can't assign your right to benefits, you can still assign a right to your received plan documents or your right to bring breach of fiduciary duty claims. And so you want to have, if this is the kind of provision you want it to be as broad as possible, saying you cannot assign any of your rights under the plan to medical providers or anybody else really. You need to make sure that it's but you have to be careful because an anti-assignment clause cannot preclude an individual from having an authorized representative, which is essentially somebody to represent them during the claim for benefit process. So that would be illegal to do that, and it's not something you want to do. So there's a distinction between having somebody represent them during the claim for benefit process, which must be allowed, but you don't have to allow them to have claims to assign claims to actually bring litigation. And this is usually one of the most effective weapons you have in litigation is precluding assignments by participants to medical providers, because it's challenging for the participants usually don't care. They're not, maybe they're being balance billed, maybe they're not, but the medical providers are really the ones that are bringing these claims, and they do so in the aggregate with hundreds and hundreds of claims by individual participants. Mm-hmm. So this is a very, very effective weapon. We'll probably skip the rest, but yeah.
So overpayment recovery, Andrew?
Of all the kind of unknown things that health plans probably are not aware of, it's of all the overpayment recovery litigation. This is a really technical area of ERISA, and it kind of, and I could.
Andrew, was that a punchline? This is a really technical area.
Yeah, exactly. And I could, if I wanted you to all kill me, I could tell you I'm going to spend the next 20 minutes talking about 19th century trust law, which I won't do. But essentially, ERISA, the question becomes, inevitably there's going to be payments that are made in error. Either they're made just accidentally, or sometimes they're made because providers are making fraudulent bills. You have fraudulent providers for submitting fraudulent bills, which is something that's certainly not ubiquitous, but it's not uncommon either. And you have a situation where years after the fact, you start to find out that your health plan, or maybe your TPA finds out that your health plan has been overpaying bills. Because of some really ugly sort of drafting errors in ERISA, kind of the combination of like the ERISA's remedial provisions, but also ERISA preemption, which really limits your ability to bring state law claims. You can't just go into court and say, hey, I overpaid you. It's challenging, it's difficult to go into court, I'll say, to just go into court and say, hey, I overpaid you, I want my money back. You have to, if you want to bring claims under ERISA, you actually have to have contract provisions that let you go get the money back. And these literally have to say that you have a constructive trust over assets that were wrongly transferred, and all these kind of really technical requirements that I won't bore you with. But it's very, very important to understand that you have to have broad language in your plan that allows you to go to recover overpayments that are made in error. You want to make sure that these that they also cover third-party recoveries. So if it's not just money that you necessarily sent out, but also if this provider or somebody gets money that should be yours, it should cover that. You want to make sure that sometimes it's hard to get those benefits, sometimes it's hard to get the money back, so you want to make sure that if there is an overpayment, that not only can you go get the money, but you can also just say that participants who might have participated in this wrongful behavior or engaged in some shady behavior, that their benefits in the future can be offset by these amounts. And you want to make sure that the provision says that if we recover these funds and it was wrongful that the medical provider had them, that you're going to recover your attorney's fees as well. Again, there's a lot more to this. I just want to flag this as an issue. You want to make sure this is really important because there's a lot of money at stake. You want to make sure that your overpayment recovery provisions are up to date. Mm-hmm. And
yeah,
you have any comments?
No, and just, I was going to say, subrogation, Andrew, you're going to talk about that too, but again, this is some other language that's very important to have in your plan document that you're having to the participant. Subrogation.
Yeah, just again, subrogation and out-of-network overpayment recovery terms are similar. Subrogation essentially happens, you have a participant who is engaged who was injured in a car accident, for example. You've spent $200,000 on their medical bills. And they go out and they recover a tort recovery from the insurance company or for the driver who hit them for $50,000. Well, a lot of that money should really go to your plan because that money is really for the medical bills the medical injuries that they've recovered. And everybody has their own practices about how much they want to do this. Obviously, there's a sympathy factor in terms of the participant who's injured. It's hard to figure out how much of that's really for their medical bills versus lost wages versus pain and suffering. It's a delicate thing, and employers are understandably somewhat hesitant in terms of really using all the power of their subrogation power that they can. At least they want to be thinking carefully about how to do that and when in the situations in which they want to do that. But it is absolutely essential that you have plan language that allows you to do this, again, because of the technicalities of ERISA. If you don't have it, you're going to be really limited. You want to make sure that it's broad, that it doesn't that there's certain common law doctrines that are not encompassed. The make whole doctrine and common fund doctrine, which I won't go into, but just to make it clear that you get every dollar the plan has the right, at least. It doesn't mean you have to enforce it, but it has the right at least to recover every dollar of payments that were paid on behalf of that participant for their injuries. And you also want to make sure that as a leverage to make sure that you're able to enforce these without having to go to litigation necessarily, or hopefully without litigation, that you make sure that if the participant refuses to cooperate with you, that you're able to recover attorney's fees and costs.
Yeah. One brief thing, there was a recent, I believe it was a Supreme Court case where there was a situation where a person had gotten paid one of these tort payments, and then a multi-employer plan tried to do some recovery, but they basically dawdled. They waited a year, 18 months or anything before trying to exercise their rights. And again, this is a very complicated area, but if you are trying to do some sort of recovery, courts, I think, are much more reluctant to look at recoveries or trying to help you if the person's already blown through the money. And even if you were to get a successful judgment, if they've blown through the money, the question is, how would you ever get the payment back anyway? So I think it's important to try and make sure that participants, again, this is part of communication, understand that, hey, if you are going to sue someone, we have this right, and you should inform us right away, because if they don't inform you, then that shows that they failed to take the actions they were required to under the plan, right, Andrew and Caitlin?
And to follow up on what Tim said, and if you ever get in one of these situations, this is probably the most important thing, the high level thing that without getting into the weeds too much, is that because of the technicalities of ERISA, it's not just a matter of you have to enforce your rights or a court will think is unfair. Your only right is to get the money that you overpaid, which means that if the guy if you're the individual who got this money wrongfully from you goes out and blows it at the casino, you're going to have a very, very hard time getting it back. You don't just get a judgment for the amount of money that you can collect. You have to ask for the actual money back, which means that there's a timing issue there, because if this person gets a judgment, for example, and that you believe you have subrogation rights, or if a medical provider received an overpayment, you need to act quickly on it, because if that particular money is gone, if you can't trace it, if you can't find that particular sort of lump of cash, you're not going to be able to get it, or at least it's going to be harder to. And so if you're ever in that situation, if there's one thing to think about and all this kind of stuff, time is of the essence, and it's critical that you take action to get that money back, just because of the vagaries of ERISA and preemption and all this kind of fun stuff.
Caitlin, do you want to talk about venue and statute of limitations?
Yeah, so venue and statute of limitations provisions are luckily not entirely complex and technical under ERISA, but they are really important to get right. You'll want to make sure that each plan includes a venue clause that selects the federal court of your preference, and that the venue clause applies to all claims possibly brought under the plan, not just claims for benefits. And statute of limitations can be contractually inserted into the plan. And there should be a couple different statute of limitations included in the plan, both for filing claims in the first instance, but also providing some sort of contractual statute of limitations for when post-exhaustion litigation needs to be commenced. And as Andrew previewed earlier, it's important to make sure that these provisions are in logical places in the plans. There's case law that basically says if you've buried them or if you've put them in some sort of ancillary document, that's not good enough. So it's important to put them in either the legal notices portion of the plan or the administrative review process, and then to make sure that participants know these provisions, include it in a claim denial or include it in extra communications to plan participants, so there's really no argument that they didn't know about these reasonable terms.
Yeah, the one thing I would say quickly is I think it's becoming more and more well understood that it's wise to have a statute of limitations after exhaustion, after your claim for benefits is done. And I think, a general rule of thumb is nobody's going to have a problem with a year. Less than that, probably not, but a year is certainly going to be fine. But it is very, very important to have a statute of limitations for when a claim can be asserted, because otherwise you get in a weird situation where under some state laws, arguably 10 years later, there's no limitation on it. You can file a claim anytime you want, and there's just no limitation at all. So it's a little nuance that's sometimes hidden and sometimes not always perfectly understood.
So why don't we do a brief wrap-up on arbitration?
I'm sure a lot of you have dealt with sort of arbitration clauses in employment. There's a very interesting question as to how much and how often they can apply to ERISA claims. I guess I'd just say that if it's something you're interested in, there's at least arguments about it, and it's something that can be pursued. You have to ask yourself, do you want to be able to do this? Do you want to have 1,000 arbitrations? And but we'll just leave it at that.
All right.
Oh, I was just going to say thank you very much.
I was just going to ask if there were any questions. I think we have about a minute left. If there's any questions or anything, and then Caitlin, Andrew, and I will be around for a few minutes, and we have a 5-minute break before.
We do have a 5-minute break, so we'll see you in 5 minutes, and we'll be doing a panel on healthcare trends.
Thank you.